So I'm going to start with relevant rulemaking that you all are going to want to be engaged in. Oregon Farm Bureau, Oregon sick time rulemaking. You're probably asking yourself, wait, this already happened, this law, or this sick time is law now. Why are we reopening rulemaking? Well, Farm Bureau and several other business organizations were pretty dissatisfied with the sick time rules that came out the first time. Mainly, there was a lot of legal uncertainty. It left a lot of you vulnerable for civil suits, especially from potential employees. So we had some very big areas of concern. One of those was piece rate pay. The law specified that as an employer you could pay, unless there was a regularly established rate of pay that you'd be able to pay, the state minimum wage for sick time for those folks. The rules were less clear, so we were looking for some clarity there. I've listed here, it's pretty dense, but I've listed some of the biggest changes in the new draft rules, which we're going to need everybody to comment on by September 26th. So that's right around the corner. Farm Bureau will be providing some draft comments. But some of the biggest changes, there was positive. I'm leading with a positive, and then we're going to go into some of the negative changes. So first positive. In the original draft rules, if you farmed in Albany, but you had a farm stand in Portland for 3 months out of the year, you were automatically brought into the Portland sick time policy. So that was if you had 6 employees or more, you would be paying sick time instead of the 10 that is statewide. We got clarification that if you have a temporary location within Portland, which is a city with 500,000 people or more, that you will not be forced into the Portland sick time ordinance. So that was a positive. Rulemaking went downhill from there. You will read in the bill, in the law, that family members are exempt from the count. Not so, says Bully. Now, they reread the law, and they found that they were not given the flexibility, despite the plain language in the bill, to exempt family members from the count of employees employed. They said that corporations cannot have family members, so only sole proprietorships are exempt. So LLCs, S Corp, C Corps, you are all now counting any family members who you're doing withholdings for. That's going to pull a lot of farms into that 10 employee threshold, unfortunately. And we're going to be commenting on that and encourage you all to comment on that, about the big impact that is going to have on your farm. I think it's going to pull in a lot of families who were trying to structure around that 10 employee threshold. They modified how piece rate pay is calculated. Again, legislators specified, and they said, unless you have a regularly established rate of pay, if you have somebody pruning for $12.50 an hour, and then they're doing piece rate work as well. So unless they have that regularly established rate of pay, then you can pay them minimum wage for sick time. And at that point, if you read some of the testimony on the Senate floor, the senator said, we understand that piece rate is an incentive-based pay system, and we want to make it fair. Because otherwise folks are just going to leave and go to the next farm and take their piece rate pay. Unfortunately, Bully, upon rereading the statute, said they determined that, no, they do not have the flexibility to allow folks to pay the state minimum wage, even though it's in the bill. Instead, they have modified how you calculate piece rate pay to this formula here. So you must add the employee's total earnings to the pay period in which they took the sick time, and then divide that by the number of hours worked. And then that is what you're going to pay them. So if the average is $18.75, that is what you're paying them when they take sick time during that pay period. It's a huge change, big policy shift, and it's not what the legislators intended. And if they do not work at all in that pay period, it's from the previous pay period in which they worked hours. So very big changes. I'm sure you all will want to comment on those and discuss how that's going to impact your farm. I would encourage you to. And I would encourage you for this reason. I know you don't have a lot of time. We provide you with the template, but I go into those rulemaking meetings and Bully staff say to me, we didn't hear from any farmers, so this isn't an issue at all. And that kind of underscores, legislators say the same thing. We didn't hear from any farmers, this must not be an issue. It's an issue. I know you guys are busy, but we try to make it easy. So, comment if you can. Rulemaking continued, joint employment. You just heard from David on some of the issues surrounding joint employment. Two big changes in the rules. The first draft of the rules, so round one of the rules, essentially said that you were jointly liable as a secondary employer with the contract employer for all sick time, rate of accrual, reporting, and notice requirements. That, for us, was too broad. And so we went back into rulemaking, and Bully slipped in this first bullet here, which I think everybody should pay attention to, into the new rules, which essentially says, if you as a secondary employer have an employee who's perpetually sick, and they are not consistent on the farm, but they've been employed by this contract employer for however many months, and they're getting paid sick time, you cannot request a different employee. You can to fill those those hours that they're not working, but when they are ready and able to come back to the farm, this just got slipped in. Apparently, you cannot request to have a different employee. So that is what you're stuck with. Positive change, we're still working through interpretation of this provision that a secondary employer is only liable for those hours that the temporary employer, or that the temporary employee works for them. So under the previous rules, you were liable for everything. A secondary employer and any wage theft claims would come back to you. This, I think, is a positive change. We're still working through some of that. I think we've got lawyers looking at that provision to ensure that it is. So everybody write down this email address. This is where you can send your comments, paloma.sparks@state.or.us. And go to our advocacy website, which I'm sure several of you have probably sent in comments through that. It's right here, OregonFB.org/advocacy. And by the end of this week, I will have posted some draft comments that you can modify and send in. You don't have to send them in directly, but if you want to, you can send them in to Paloma. All right, next big issue coming on the horizon. State retirement for the private sector. Yes. I wasn't done right. Yes, no, of course. I guess while I'm here, does anybody have questions while we're finishing up writing on this piece? On how this happened? Because I'm also wondering how this happened, yes.
So on that first bullet, can we refuse to have them work on our farm further? Or just they have to have the chance to come back? If I didn't like their work before and then they went sick, do I still have to let them back?
That's a really good question.
So should you let somebody back if you didn't like their work after they start getting sick? And the answer to that is easy, right? Because that's what happens all the time with not just contract labor, but with our regular labor force, right? We don't like what they're doing, now all of a sudden they're getting sick, or they whistleblow, or they did whatever to get protection. The answer is, how was your documentation, right? If we can show that they were really terrible, and how much documentation are you keeping on contract labor? Right? None at all. Unless you've been, because I'm sure you complain to the supervisor about them, or whoever the contract laborer is, the owner, you say, hey, this person's got to go. But unless it's documented, how are we going to be able to prove that? If we can prove it, then we've got more leniency there. If we can't prove it, I'm going to say, bring them back, give them enough, and you can document after the fact and say, hey, look, you're back. Somebody else was doing this job way better than you. You now need to live up to this standard. We've been trying to discipline you along the way, and now we want you out. So I'd say you got to treat them with more kid gloves. And just while we're on joint employment for a second, I got a question after from the investigation section. When we're doing investigation, do we need to investigate joint employees, contract labor? And the answer is yes. They are joint employees. They are employees of yours, even if you're not paying them. So all those obligations still kind of fall on us, and I'm not surprised at all to see this.
All right, state retirement for the private sector. This bill passed. It's not PERS. It's going to be a lot like PERS in a couple of years, is our fear. This bill passed in the 2015 legislative session. They've been in rulemaking for 2 years. It's going to be implemented in July of 2017, so we still have some time. And the implementation of rulemaking chart is so confusing that I honestly cannot tell you when comments are due. They're either due in September at some point, or in December, or potentially October. But the folks in charge of this, we put in requests many times to figure out when these comments are due. And we received back the same like 20-step chart. So once we know that, we'll post it on our advocacy website so that you all can send in comments. I'm thinking it's probably not September. But, so the temporary rules are incredibly broad. They pretty much just gave the treasurer's office blanket authority to implement this program. We all know the state's track record with large IT projects. I think we're all disappointed with that track record. I don't have a lot of faith in it. And ERISA questions still remain. So the state was supposed to give this system 2 years to be implemented to figure out whether or not you all automatically opting in every employee would be you giving them financial advice, which you're not allowed to do.
What's the acronym ERISA?
It's,
Employee Retirement Income Security Act.
yes, yes. So it essentially just says you as an employer or you as a state cannot be forcing financial advice or giving financial advice to your employees. But by automatically opting them into a system, a retirement plan, are you giving them that advice?
ERISA is the federal law that controls all 401k plans, and so most benefit plans under this. And so there's some question about whether ERISA actually preempts this, and so there's other issues out there about whether what we're doing is even legal to begin with, requiring the system.
Yes.
So.
Exactly. Our concerns, I think we have many concerns that working within the system. So employers automatically opt in all employees on day one of employment. Employee is still being defined by this rulemaking board, and they just invited Farm Bureau to join. Our concern right now is around seasonal migrant workforce, identification, how folks are going to access that money when they want to take it back out of the system. Those questions aside, I think the biggest issue that we're going to ask to be addressed is the liability that you all are going to have in the employee opt-out. We are going to be asking the treasurer's office for a state form that essentially gives employees in multiple languages directions on how to opt out of this program. I think I hear from a lot of farmers in the Willamette Valley, and they have told me about, an employee will show up for one day, and then they'll go to the next farm, they won't come back to my farm, and then they're there for a week and a half, and then they're going up to Washington, and then they're done in Washington, they're going down to California. So maybe they opt out after that first day, they decide to send a form to opt out of state retirement on your farm. They go to the next farm. We need to make sure that if they're going to be opted in potentially. It's day one on the next with the next employer. I think there's a lot of sticky issues around contract employers, again, joint employment, joint liability, that we're going to be working out. So as soon as we get to that point, we're going to send around comments. I think the best thing we can do is ensure that we give you all of as much of a liability shield as we can with the state forms. So, yeah.
So if you already have a 401k set up with your employees, this will affect that?
Potentially, it has to. Your 401k that's set up for your employees has to meet the requirements set in the state program. And they haven't set those requirements yet. They're just kind of working on what that's going to look like. But not every plan is going to fit what the state's looking for employees.
So we're hoping that this, I think what I'm hearing is, you're hoping that the state will mirror what the feds, this already is, because 401k is already active for rules. So I'm just, bad questions.
No. I think our big concern in 2015 was that the state was pushing this without regard for the overarching ERISA. And they didn't seem, and they just wouldn't ask the question. So I don't know where we are at this point with regard to, that's huge liability concern, and it should be for everybody, for the state and for employers.
Well, the other problem I would see as a concern is if
people have a 401k and IRS set up, and then you have to switch things to meet the requirements of the states, there's penalties and liabilities, penalties built in for accessing those funds at the federal level because you can't touch them, you can't move them. Yeah.
It's more of a setup issue, and so we may need to have plans that are revised at the setup time to make sure that it complies with that, to allow more participants in earlier or something like that, rather than
I guess-
wholesale changes to what you've already done.
I guess that's what I was looking at, is if something's already in place.
So it's, the question of eligibility usually isn't something that where you get plan penalties.
So for folks in this room, there's a lot of talk about the first group that's going to be automatically signing up, their employees being those who employ 500 or more employees. I can imagine some folks who, I've heard some of the blueberry growers have like 600 pickers. That could potentially pull them into that first year. I think probably a lot of people will not be included in that first year implementation.
And that 500 is still not defined whether it's quote-unquote year-round versus seasonal.
No, I mean, when the debate was happening in the legislature specifically wanted to cover farm workers, and so that's why it was all employees on day one. So they might, I think that there's broad enough rulemaking authority that the retirement board could potentially structure something around using some already existing definitions, structure something around seasonal employees. They don't even, I mean, I was looking through some of their transcripts from their rulemaking, and they don't even know to call that farm workers aren't farmers. So they were talking about automatically registering farmers that are seasonal, and so they just don't understand our industry, which is why I'm glad that we're going to get a seat at that table. But the whole plan is going to be finalized by December.
The cost for the farm?
The HR burden cost.
So what, is there an estimated cost of the?
I mean, there's going to be a cost to everybody just to add it to your payroll to automatically withhold some payment, but.
What percentage of it?
Oh, well, it's not gonna, you all are not gonna be paying, you're not gonna be putting in any employer match to begin with. I forget what percentage it was it 2.5 or 4?
I don't know what it was. David, do you know?
I don't know.
I don't know off the top of my
It's
head.
not the
Comes out of the
employees.
employees.
It comes out of the employees, you're just taking it and you're putting it into an account with the state.
I'll say yes.
It's a forced to the savings account.
It's for everybody? I mean, it's not,
Unless you already have a retirement plan that meets the criteria that you offer to your employees.
no retirement plan, so the state's making us do this?
Yes, they are.
Because they're so good with first.
They're not gonna touch it.
Why would they do that?
Yeah. So California and Illinois are the other two states who are kind of going down the same path as we are. I think everybody's heard, if you haven't, about the troubles that Illinois has had with their PERS system. There's not a lot of good models for this, unfortunately. Wage theft, everybody's favorite topic. Legislation passed, I believe, that looks like a 2016 bill. And we are going to be embarking on rulemaking for this wage theft bill in this, it should be in the next couple of months. This is real small print, so this bill had 2 requirements. One was that it created a new, I think it was 2 new wage enforcement specialists funded through an employer-paid wage security fund. And they are just going to be pursuing cases of non-payment and underpayment of wages. Bully's story that they tell every year in the legislature is, oh, we aren't able to fund any of this, so wage theft goes unchecked. And then legislators throw all these bills, actually just penalizing the good employers. And so this was a negotiated deal. Farm Bureau did not come to a negotiated table on this one. This was a negotiated deal with some of the business groups. But the big change, in addition to funding new wage enforcement specialists, is new pay stub requirements. I think many of you already do this. We were talking to our attorney, our general counsel, and he thought that many of you, not all of you, are already following these pay stub requirements. This is gonna be a big change for other employers. Yes.
So I was just told by our payroll company, that they, as a company, are choosing to remove the federal ID number from paycheck stubs from their own employees. They left it on our, because I was afraid that needs to be on there. Because they're afraid a lot of the information that's come out regarding fraud lately has been an issue, and they're prepared to go to court and fight that, if they have somebody said something or if it comes to that. But they are concerned about how much information now is being presented on a paycheck stub by providing now with the federal employee ID number and everything is, I haven't seen the document they came out with regarding some fraud things that were going on, but that was a choice that they're making currently.
So that aside, in Oregon, they're gonna be required to list all of this. And if they want to challenge that, they can come and challenge that.
And federally, it's been required.
Federally, it's been required.
Yeah.
Under this fact.
And I don't see, well, yeah, we've got tax ID of business. Here's your piece rate requirements down here. I'm sharing this whole presentation with Roberta so she can share it around, because I know a lot of you probably can't see that really small print, and I apologize.
That's what I was wondering.
Yes. I will make sure that this gets sent around.
And it's stuff that was in it's all text that was in our newsletter and our previous issue, the most recent one. It's all in there.
So I'm not too concerned as a policy, as your policy advocate, I'm not too concerned about these provisions. A lot of the business community sat at the table while this was drafted. I am concerned about the rulemaking process, which if you can refer back to the paid sick leave, take 2, which can go really south. And Bully can start interpreting different provisions of the law in very interesting ways, strict in some instances and very flexible in others. And so we're going to be really engaged in that because nobody really knows what's going to come out of this rulemaking.
You just say tax identification number, so we can use our Oregon number?
To be honest, I do not know.
It doesn't have to be the one that are.
It's the number for the business, and I'm not a lawyer, but
I think it's the EIN, I think it's the federal.
So we do have to use the federal one on there, we can't use the Oregon one where we pay our Oregon state taxes under.
you know what, we're going to be going into rulemaking on this soon, and I can ask that question.
The law doesn't actually state one way or another which it is.
Bully will decide. So, in rulemaking.
Of course they will.
Yeah. All right. I'm going to end with some good news, so we're going to keep on the same track with here's what's coming in 2017. Before we go into that, here's a preview of what you all have seen over the past 2 years. There's a coalition in the legislature of labor advocates called the Fair Shot Coalition. They had 5 agenda items they wanted to pass over 2 years. And what happened? They passed all 5 agenda items. Ban the box, it was protected wage disclosure, paid sick leave, minimum wage increase, and the state retirement for the private sector. So they outlined that agenda. They got the first 4 in 2016. They got the 5th one, which was the minimum wage increase. Sorry, that was 15 in 2016. This here is a picture of all of our folks testifying on minimum wage. They are a very powerful group, especially with the way that numbers look right now in the legislature. So I wanted to kind of give you that preview while we look at what their agenda is going into 2017. Mandated, predictable, and flexible schedules. I think I've spoken to you all a little bit about this maybe last fall. Folks tried, this Fair Shot Coalition tried very actively to pass this bill in 2015. There was a negotiated deal around paid sick leave that preempted this action for 2 years. So local governments can't do it right now. And local governments and then the legislators also said we're not going to take this up for 2 years. When that preemption runs out in July of 2017, City of Portland is ready to go. They've got their ordinance for predictable scheduling for that city. Eugene would be the next one to go. Why does that matter to any of us? It probably doesn't directly, but if you look at the history of paid sick time, it was Eugene and Portland who passed sick time ordinances and enforced the rest of the state to do it, because everybody should be on a level playing field. So that's why we're concerned about this law. Essentially, when you hire a new employee, you have to provide them with a predictable schedule, the shifts that they're going to be working. Those schedules must be provided 2 weeks in advance. What you have up here is the San Francisco ordinance, which says that if changes were made to that schedule within a week, that you had to pay for each hour or each shift that was changed. And then if you had on-call employees, then they had to be paid at a premium rate if they weren't called in. So Seattle and San Francisco passed these ordinances. Well, Seattle's still working through theirs. San Francisco's passed their ordinance. Seattle's projected to pass it. But they only right now apply to retail and service sectors. In Oregon, the Oregon bill wasn't specific to those sectors. It did allow for a certain opt-out if it was too burdensome. Again, Boley would determine that. We thought that harvest might be covered under that, but our law that was considered in 2015 was not specific to retail and service sectors.
I'm thinking weather. I mean, you know,
Exactly.
Ice day or it's over 100 degrees and you don't want you guys painting, so how do you?
You can't predict it, nor can you provide a forced flexible schedule, which is the other component, I didn't put that up here, of this bill. It's a very ironic piece of legislation, because first it requires you to put in place these predictable schedules, but then requires you to accommodate flexible schedules if your employees have a second job, a family, or if they're in school or workforce training programs. So those are the components of the bill. It actually sounds, I think, whenever I brought this up in other groups, in other ag groups, they've laughed out loud because it's that ridiculous. It's that absurd. Let's make sure it remains that absurd for our culture. And when we put out calls to action in next spring, we need folks to be sending in comments and making sure that we are fully exempted from this plan. Again, Fair Shot 1 and 2 pass both their agendas. They are a very strong force to be reckoned with, and if things do not change politically in the state this November, we need all hands on deck to tell the story. So, paid family leave. It's been pretty quiet from the news, I guess, with regard to paid family leave. New York and California passed recent statewide policies. California had a state disability that paid for a portion of their paid family leave for quite some time. But as I was doing some research for this has kind of been in the back of my mind, it's something that will impact you all in a very big way. I saw the Fair Shot agenda the Fair Shot Coalition with another group that's made of all the same individuals called Family Forward. Has put together a brand new coalition called It's a Time for Oregon. And that coalition recently published what they want. They published it over Labor Day weekend for their paid family leave agenda for 2017. And that is a social insurance program administered by the state. So another one of those. Employees and employers, apparently they see contributions coming from both sides. And I don't know, so California has a 6-week policy, New York has a 12-week policy. I don't know where they're gonna land, they didn't publish it on their website. But they want folks to be able to use their paid family leave for any of these 4 qualifying purposes: birth or adoption of a child, foster child, an employee's own serious illness, or the serious illness of an employee's family member. Y'all should look at these two, because don't we already have paid sick leave for that purpose? Right. So this is family leave. It's ambitious. This was a note that they had on their website. Payroll contributions vary from state to state, but are generally about 1% of payroll, capped at a specified amount. So there's your new tax on your payroll. Your new plan, which 6 to 12 weeks. I think this has a lot more potential, honestly, of passing than predictable scheduling does. Predictable scheduling is passed only in a couple little cities, and there's been a lot of conflict around it. 2 states have passed this. which means there's precedent for us to pass this as a state. If we cannot meet it, we need to talk about what it looks like to have a 100% employee paid contribution so that the burden's not on employers. So just want to kind of put that out there, something for you all to noodle on. It's coming. This one has serious potential for passing. So I saw a hand somewhere. Nope? Yes, no, okay. Moving on. Ag overtime. Yep. This one we are holding our breath on. We're not talking about it in public forums right now because no legislators here are talking about it. However, advocates for ag overtime are starting to write into senators. I've heard from several of them they're starting to get emails on this. So ag overtime. California has had an overtime policy for over 10 hours. Big fight is passed with their Senate, their House. It's not been signed yet by their governor in California. This is what it looks like. Time and a half pay for working more than 8 hours a day or 40 hours in a week. Double the pay for working more than 12 hours a day. And these pay boosts are going to increase incrementally over 4 years. However, there's provision here that the governor can suspend them for a year if the economy falters. So, I wanted to highlight this for you all. This is not on anybody's public agenda yet. And California does have a different situation than we have. However, we have a very progressive legislature that is going to see this as a huge win for working Oregonians. And I could see this bill being pushed in 2017. And I just want everybody to be aware that when and if this bill is passed or pushed, we are going to need all hands on deck to talk about this. And again, we provide the platform to do it over our advocacy website. We host days at the Capitol. But if we're not talking about it, somebody else is telling our story. And they're giving us a really bad spin on that story. So, all right, positives. What are we gonna do in 2017? Right now, we are gonna have 2 bills put forward on sick time. One is a farm owner and family member exemption from the employee count. Some of the committee chairs have expressed an interest in doing that bill for us. Piece rate pay. We're going to fix piece rate pay. Get back to what legislative intent was. And then minimum wage. There was a lot of talk at the end of 2016 about trying to piece together some sort of wage relief. That talk eventually moved for legislators from a training wage or an ag wage relief to a youth wage discussion. We've been sitting on a work group around youth wage, and they've come up with 3 different proposals that they're considering. First is to invest in more state-run programs to support youth workforce. Not our favorite option on this list. Youth minimum wage or training wage at approximately 89%. Other states have that. Honestly, they've not worked very well. The market kind of forces everybody to pay at least the minimum wage. And I can tell you right now that the unions and farm worker union are very much against the youth minimum wage proposal. So the third is probably the most politically viable here. Payroll tax credit for employers who employ folks from the ages of 15 to 24. Once you get past 18, it starts tearing down to avoid a total benefits cliff, essentially. So you keep those 20, 21, 22-year-old folks employed. We don't know how much that's going to cost. There's a lot of factors at play with that. I think that's more politically, well, I don't know how politically viable that is. Probably more politically viable if Measure 97, which is that grocery tax, passes, because there's extra money to play with for the state. If it doesn't pass, then every tax credit we already have is on the chopping block, as are deductions for property, or for personal property.
And if we're hiring all the young people in detriment to all the old people.
That's not fair.
I want to know how they're going to know what ages they are after they're 18. Who's going to be asking that question? I'm not going to ask it. 24, 23.
It's on your mind. It would be on the new hire report that you have to send in.
Yeah, that's ridiculous.
So here we we go, end of presentation. Do we have any questions? Here's my email, write it down if you have questions. Happy to answer those. And please, 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 if you aren't signed up for the advocacy webpage, sign up for it so you can get alerts and at least know what's going on.